Absent.
Okay, and you said 5 minutes for?
Yes, please.
Very good.
My name is Laura Dempsey as well. I'm here on behalf of the state of Florida, the appellant in this case. We're here this morning on a granted C4 motion to dismiss for carrying a concealed firearms charge. The defendant in this case was driving his Hyundai Elantra southbound on 54th Street North when he approached an intersection and turned right without stopping at the stop sign. Tampa Police Department initiated.
Maybe it's me, but I need you to just speak up a little extra. You
Yeah, I'm
said
having trouble.
Okay,
projection.
I apologize. It's my first time with the microphone.
I think you're just going to have to speak louder.
Okay, okay.
Thank you.
He turned right.
Don't hesitate to shout at us. We understand why.
Okay. Turned right at an intersection without stopping at the stop sign. Tampa Police Department initiated a traffic stop. During their interaction with him, they smelled the odor of burnt marijuana and saw a handgun in his glove compartment. At that time, they asked him to step out of the vehicle and placed him in handcuffs. Throughout this interaction, he wore a crossbody bag, which zippered closed and contained a loaded handgun. It is that gun for which he is charged with the carrying a concealed firearm. The trial court granted its motion to dismiss based on the private conveyance exception to the statute. But just to lay the groundwork a little bit, if we look at the original charge statute, it uses the words carries and, it prohibits the carrying of a concealed firearm on or about the person. The exception allows the possession, which is a much broader range of conduct, of a concealed firearm in a private conveyance if, and I want to quote this so I don't stumble on my words, if the firearm or other weapon is securely encased or is otherwise not readily accessible for immediate use. So, for example, that would allow the gun to be carried in the trunk of the vehicle while you're moving. However, the same subsection continues on and says, nothing herein contained shall be construed to authorize the carrying of a concealed firearm or other weapon on the person. Now that sentence is not contingent on any conditions, and it's written in a way that governs the rest of the subsection. It's undisputed in this case that the defendant was carrying the gun on his person. So that's conduct that's expressly not covered under the exception to the statute. The case law that the trial court distinguishes actually also supports this reading. In both Gemmell and Dowdy, the 4th DCA gave 2 independent reasons for why the private conveyance exception did not apply in those 2 cases. It was both that the defendant in those cases was not in a private conveyance, but also independently, each defendant was carrying their respective weapons that they had on their person, and that's an independent reason for why the private conveyance exception could not apply to their conduct.
Let me ask you a question, and I don't believe either of the briefs cited some of these cases, but there are a line of cases, State v. Lopez, which comes from our court from 2008, Herring 2006 from our court, and then Brunson is a 4th DCA opinion from 2017 that kind of follows those cases. But they talk about with the statute that the concealed weapon has to be simultaneously on or about his person and concealed. I don't know if you're familiar with those cases, but it seems to me that's what doesn't exist in this case, because the concealed weapon is actually encased in a pouch that's attached to the person, correct?
I'm not sure I quite understand your question, to be honest. My understanding is that it's undisputed that it's securely encased. My argument, and the state's argument, and the language of the statute in my reading of it is that because it's on his person, it doesn't matter that it's securely encased. So because he's carrying it on his person, it's not protected conduct. Does that answer your question?
Not necessarily, I'll go ahead with your argument and I'll see if I can ask it a different way.
I apologize.
That's okay.
And maybe, hopefully this point gets to your question a little bit. Even putting that sentence aside, the nothing hearing sentence aside, the statute requires that the firearm not be readily accessible for immediate use to the defendant. Now, there's an Alexander case from the Florida Supreme Court from about 40 years ago that interprets the language of the or is otherwise not to make the primary requirement of this exception applying to be that the firearm is not readily accessible for immediate use. And readily accessible for immediate use is defined by the statute, and it says that the firearm or other weapon is carried on the person or within such close proximity and in such a manner that it can be retrieved and used as easily and quickly as if carried on the person. So a bit of a circular definition with the on the person exclusion. Here, it's securely encased, but it's also readily accessible if for some reason this court does not want to look at the on the person, carried on the person language. He would fail under that condition as well.
I'm not sure I understood what you just said. If the court doesn't want to look at who's on the person.
So, in other words, there's two independent reasons why you can find that it fails. It's because it's carried on the person language, and then in addition to that, independent reason why the conduct in this case is not covered under the exception is that the gun was readily accessible for immediate use to him. It was just behind a zipper. It's carried on his person, which is prohibited conduct under the exception as well. Or excluded from being protected by the exception.
You're saying that no matter if the state position is that no matter how the gun was carried on the person, whether it be in a zippered pouch, in front of someone's pants or behind, or in a jacket on a person, that regardless of the zipper, it doesn't matter, it doesn't fall within the exception.
If it is readily accessible. And
Well, then let me ask you the question. So it's in a zippered pouch in a state position that's readily accessible.
yes,
Okay,
it's
what if it's in a pocket of a jacket on a person?
so I think this goes a little bit to the definition of what is securely encased. And it's my understanding it's relatively undisputed. There's a definition in the statute which talks about a zipper gun case. But I know there's case law, and even if we just look to the two cases in that the trial court looked at that I already mentioned, in both those cases, I think one's described as a zippered waist pouch and the other's some kind of other zippered bag under his shirt. In both those cases, it was considered on his person, and I believe also securely encased was not in dispute. And so I don't believe that whether it's securely encased governs.
You're saying it's a two-part test. It has to be securely encased and readily accessible. Well, excuse me, it has to be readily accessible for a violation of statute if it's on the person.
I believe that on the person by proxy makes it readily accessible. However, readily accessible would cover more things than on the person.
Because it could be on a floorboard, underneath the seat, is what you're,
Yes.
that's my case.
And, right, exactly, and there's cases on that I don't have in front of me because I didn't feel like they were, as on point to this question.
And in Alexander, did they reach the readily accessible or did they just focus on the encased?
So Alexander, my understanding of Alexander was about the constitutionality of this, and the primary relevance of it is just the interpretation of the or is otherwise, and what the legislator meant when it said or is otherwise not readily accessible for immediate use. The Alexander case interpreted that to mean that exactly what we're saying. If it's securely encased but is also readily accessible for immediate use, it is a violation of, yes, it is not covered under the exception. And is still a violation of the carrying concealed firearm charge.
There are cases that say a firearm in a closed center console, not a locked glove box, but the closed center console is not readily accessible. And so here you have the weapon, what I believe is securely encased because it's a zippered compartment, zippered carry bag, I guess, but it's on his person. So is that the distinction you're drawing, or is the securely encased part a bit of a red herring in this? Because I don't see that it's not securely encased under the law. I mean, if a closed console right next to where I'm sitting, and there's a loaded weapon in that center console, and that's considered to be securely encased, a zippered carry bag, wherever located, seems to me to be securely encased. It's just a question of whether or not it is illegal to have it on the person.
So my understanding, if we look to some of the analysis in the case law, let's look at, Dowdy, for example, says that pursuant to this exception, that they talk about the handgun was securely encased in his zippered handbag. And then this is a quote from them. Yet pursuant to the unambiguous language of this subsection, even a securely encased weapon does not fall under the private conveyance exception if it is carried, quote, on the person.
Well, that's
Exactly, that was his point.
Yeah. So the security encased doesn't seem to be an issue, but
Yes.
it's on the person.
Correct, it's,
But I thought you argued a minute or so ago that another way to analyze this is it securely encased or not, because it's on his person? I mean, it seems to me it is securely encased.
yes, we are not disputing it is securely encased. It's undisputed, in my reading of all of the briefs and arguments, it's undisputed, it's securely encased, it's undisputed, it's on his person, and it's undisputed, it can be considered readily accessible for immediate use. So when all of those factors are at play, how then?
But isn't the readily accessible aspect diminished if it's securely encased, such as in a center console?
I would imagine so.
So again, it turns only into our interpretation of the statute and whether the exception within the statute as far in possession, whether that controls or doesn't control under these circumstances.
Yes, if I'm following you correctly, yes, I believe that I agree with you. So my interpretation of the appellee's argument is that it would require the word possession, which is used in
It would require actual possession. Because their argument turns on constructive versus actual, right?
My understanding of their argument is they want that word possession to include actual by the legislator's lack of use of constructive specifically. But it would completely erase the added language that they included later in the statute to prohibit, in other words, the legislator used other words, but in reality, they prohibited the actual possession of.
It doesn't really matter, because didn't wasn't he in actual possession with it being carried on his body?
Yes, yes, Your Honor, that's my understanding.
So Council, you're at your 5-minute mark if you want to reserve the rest.
I would like to reserve the rest of my time. Thank you.
My name is Alon Michael Isaac. I represent Mr. Valley with the applicant in this case, and I am asking the court to affirm the ruling of the trial court. It's our belief that the trial court judge correctly applied the law, correctly applied the statute, correctly distinguished individual facts in this case from any existing case law, and we're asking you to affirm the dismissal of charges against Mr. Valley. Let me start out by saying Mr. Valley was put in somewhat of a catch-22. When he was pulled over, he was ordered out of the vehicle. If he doesn't get out of the vehicle, he commits the crime of resisting without violence. The moment he got out of the vehicle, in compliance with the police officer's order, he no longer was entitled to the vehicle exception. So now he was outside of the vehicle. He was carrying a CrossFit bag that was zippered with a firearm inside. And like some of the other cases, whether it's Doty or General or the Aaronsman, he's now outside of the vehicle in possession of a loaded firearm.
Okay,
So,
but he has to still fall within the exception of the statute. And so what we have to determine is whether or not he was permitted lawfully to be carrying a concealed weapon on his person in the private conveyance being the car.
and with all due, and I believe the statute permits that. So,
And help me out with the language towards the end that says, nothing herein contained shall be construed to authorize the carrying of concealed firearm or other weapon on the person. That's where I'm having difficulty following the affirmance.
So, and you know, I think that understanding that I analogize my argument to essentially what Justice Scalia did in Heller. He talked about the Second Amendment, and it's in two parts. There's a prefatory clause and an operative clause. If you apply that same logic here, you have a statute that says possession, not constructive possession. The statute doesn't say transportation. A little bit of a digression. Their argument seems to suggest all you can do is transport a firearm in a vehicle. You can't possess it. That's not what the statute says. It doesn't say you're entitled to transport. It doesn't say you can only constructively possess. It says you can possess. And
What it also says is that a person who possesses a handgun or other weapon as authorized under this paragraph, which means means secure or not readily accessible, may not carry the handgun or weapon on his or her person.
except in a vehicle. And this is
No,
the
that is in a vehicle.
I'm
reading 4 subsection A.
the statute, let me copy the statute.
We're talking about possession in a private conveyance.
Correct. It says nothing herein contained shall construe or authorize the
Okay,
carrying.
read subsection A.
I don't have the copy of the statute.
Okay, notwithstanding section 790.01, a person 18 years of age or older is in lawful possession of a handgun or other weapon may possess such handgun or weapon within the interior of a private conveyance if the handgun or weapon is securely encased or otherwise not readily accessible for immediate use, which we've been talking
Right.
about those.
Right?
And then it says a person who possesses a handgun or other weapon as authorized under this paragraph may not carry the handgun or weapon on his or her person. So what do I make of that?
Well, there's a difference. Carrying it on my person, this is now on my person. A gun securely encased is securely encased on my person. It's not the same. And what they're saying, the operative meaning here is, it's a clarifying. The statute, the operative aspect of the statute is to create an exception for possessing within a vehicle. The sentence that you're focusing
It
on,
looks like to me that it's like, fine, you can have it if it's securely encased or not readily accessible, but you better not have it on your person.
well, but with all
Which,
due respect,
I don't see how that's inconsistent.
well, but with all due respect, what they're saying is, we want people to understand the location within a vehicle doesn't entitle you to possess it on your person. If you are in the vehicle, one of two circumstances must exist. It's either securely encased or it's not readily accessible. If one of those two exists, you can possess it actually on your
It
person.
doesn't say that. What it said, I mean, maybe I'm not understanding English, but it says a person who possesses a handgun or other weapon as authorized under this section, which means securely encased or not readily accessible. Do you disagree with me that that's what it's referring to?
I do because,
Okay, so tell me, what's it referring to then?
because
Tell me what as authorized under this paragraph is referencing.
the paragraph is authorizing the possession within the vehicle if one or two circumstances exist. You can possess it. What they're saying is, if you're just located in a car, you can't just, because you're in a car, have a gun on you. You can only have a gun on your person if one
Okay,
or
then
two
you're
of those
reading
other
the
circumstances
words-
exist.
You're reading the words, to me, you're reading the words as authorized under this paragraph out of that sentence. Otherwise, what are they referring to?
As author, well, as authorized is referring to the exception. It has to be.
Okay, so a person who possesses it under this exception may not carry the weapon on their person.
Well,
I think I need a better explanation from you on what that's referencing and how somehow, notwithstanding that sentence, it's okay to have a weapon on your person.
well, first of all, you can look to the Florida Supreme Court case, the Alexander case. Alexander was certainly possessing it.
On the chair of the passenger seat next to them. There is no, I've gone through that case, there are no facts that.
I agree, the content, well, actually, in my reading case, it certainly was in his hands because he was unzipping it. I didn't see where there was any greater
But only
context,
to
but in
get
order
the
to unzip it, he
information.
would have had to have possessed it.
Okay, but that was, I think, in response to retrieving identification. Yeah, there was no facts in the record, and it may very well have been, but it wasn't in the reading of the case that the actual purse or hand purse, whatever they called it, was physically on that purse, Alexander at the time.
And I agree, we don't have a lot of context, but in order to unzip it, his hands would have been on it in order to unzip
But
it.
it was in direction to law enforcement asking for ID, and we don't have those facts here. So let me ask you a question. Readily accessible, do you have to satisfy or show that it was not readily accessible in accordance with the statute? I just want to know what your opinion is on that, because if I read it, readily accessible for immediate use means that a firearm or other weapon is carried on the person or within such close proximity and in such a manner that it can be retrieved and used as easily and quickly as if carried on the person.
Well,
Isn't the zippered crossbody readily accessible and in such a manner that it can be retrieved and used easily?
no.
Why?
The Florida Supreme Court in Alexander, and I'm reading from the decision. We do agree with the petitioner that his motion to dismiss should have been granted. His argument is that the firearm was in his zippered gun case, and therefore carrying of it in his automobile was not in violation of the statute.
Well, what's that?
If I can just
Okay,
finish,
go ahead.
it would frustrate the intent of the legislature if we were to hold that the carrying of a firearm in a zippered pouch, like the petitioners, was prescribed by the statute since it was no less readily accessible for immediate use. The Florida Supreme Court is saying, if it's in case, it's not readily accessible.
focused on the fact that they were saying that wasn't a gun case, right? Isn't that kind of primarily the focus of that case as well? Whether or not that case was an actual gun case, or can it be any case that's ever?
Well, I don't think it matters. They don't draw a distinction. They're simply saying, if it's encased, it's not readily accessible. You meet that standard. You don't, and to Judge Silverman's point, if the gun is in the console, it's not readily accessible. And so encasement equals not readily accessible, and that comes right from the Alexander case.
Here's where I'm not trying to agree with you, and this is an area that I want to explore. The statute says on its face, or other, let me find it again real quick, where it is either securely encased or otherwise not readily accessible for immediate use. And so though you can read the statute, including the exception, nothing herein contained language, consistently by saying it's okay if it's inside the vehicle and if it's securely encased. It's not okay if it's on the person. So why is that not a way to salvage the statute as a whole?
Because then you're going to have an inherent inconsistency, and so you're going to violate what I said in my brief is the harmonious reading. You can't say you can possess it in one part of the statute and then suggest that
you can possess it in the vehicle. You can have it in your back seat. You can even have it underneath your driver's seat or the passenger seat.
But that goes back
That
to
is possession.
But
As
that-
a matter of law, that's possession, right?
it's constructive possession.
It's possession. Does the statute make a distinction between actual or constructive?
Well,
And it seems to me the answer is yes, it does, because it says nothing herein contained shall be construed to authorize the carrying on the person.
but then you're limiting the word possession to constructive, not actual, which the statute doesn't do. As well, you're essentially, and words matter, you're essentially saying all you can do is transport. Transportation and possession are not synonymous. The interpretation that the prosecutor or the state is suggesting essentially says you can transport. You cannot possess, you can transport. That's not what the statute says.
But I read it that you can possess a firearm in your vehicle as long as it's A, B, and C, but it's not on your person. And that seems to me to give credence to that last part of the statute.
Well, but with all due respect, I think then.
You keep saying with all due respect, we do know what that means.
Okay.
I disagree.
I disagree. So, but
I mean, the point here is it's a concealed weapon, right?
okay,
Right, without a license.
okay,
At the time of the statute. I mean, I
Right.
think that's really the point here too. So, I mean, you can have it, you can possess it in the vehicle, but it's certainly in absolutely no circumstance can be on your person.
well, but that, again, I think that goes back to the fact that now, if we're going to give a textualistic interpretation, you're changing the word from possession to constructive possession. That's not what they wrote in the statute. You're essentially making it legal to transport, not to possess. That's not what they wrote in the statute. You have to have a harmonious reading. This particular sentence is nothing more than clarifying. It's telling the ordinary person, if you're in a vehicle, just because you're located in a vehicle, you cannot possess it on your person. However, if it's securely encased, if it's not readily accessible, then you can. That's the meaning of this statute. Otherwise, if you adopt their interpretation, you have an inherent conflict because you have a portion of the statute that says possession, actual or constructive, is permitted. But then you have a sentence that says you can't actually possess it. There's an inherent conflict. The only way to have a harmonious reading is to give the interpretation that I have suggested, and that is that it's a clarifying sentence. This sentence is not part of the operative clause of the statute. Going back to the analogous argument that Justice Scalia had when he was talking about the Second Amendment. It's in two parts. Just like the Second Amendment was in two parts, an operative clause and a prefatory clause, this statute has an operative element and a clarifying element. And it's telling the ordinary person, you can't just have a gun on you. You have to have some of these other circumstances that are existing to permit that possession on you.
Okay, what's your best case?
I'm sorry?
What's your best case then that we're supposed to rely on?
I'd say the Florida Supreme Court of Alexander. So, so for these reasons, I just, we believe that the court got it right. We're asking that you affirm the trial court.
Very good, thank you, Mr. Johnson.
Okay, a few clarifying points. Can you hear me? Just one point of clarification, Judge Kelly, I believe you have the most recent version of the statute. It was amended last year, so this is a,
I'm reading the wrong version.
yes, Your Honor.
Okay, thank you.
Yes. I have a,
Let's make it much simpler.
I have a, would you like, you have a copy of
No,
it?
I have it.
Okay, wonderful.
Yeah.
Okay, so I guess piggybacking off of the looking at that sentence as a clarifying sentence. In my reading of it, that would require the beginning of the sentence start with something like notwithstanding the rest of the sentence. But the language used, the nothing herein shall be, as we know, nothing herein qualifies the rest of the subsection. It is an unconditional statement that nothing herein can be construed to authorize carrying it on the person. To the argument of whether it being in the pouch when it's on the person changes whether it's on the person. Both of the cases, the Gemmell case and the Dowdy case, in both cases, it was considered on the person even though it was in a zippered pouch. For these reasons, we believe that the statute requires this case be reversed, and if there are no further questions, I'll rely on the arguments set forth in the briefs.
Very good, thank you both very much.
Thank you.
The next case is Hanover Insurance Group versus Frazier.
Well,